I'm going to mute Isabel.
Okay, let's get started. My name is Isabel. If I haven't met you before, I work at Michelson Found Animals as part of the LEAP team. Thank you for joining our webinar today. I'm going to get started and share my screen really quickly. If I can figure out how to do that. There we go. Okay. And I'm going to go into presenting mode. Sorry. How do we do that? And, okay. Here we go. Okay, so again, my name is Isabel. Thank you for joining our webinar today on labor and employment law. We're really lucky to have Brian Chase with us, who we'll be introducing shortly. He is also from Michelson Found Animals team and the general counsel here. If I can go to the next slide. Here's a great photo of him with one of our cats from Adoption Shop, and I'll introduce him in a minute. But before we do that, just a couple details about our call today. It'll be about a 30-minute presentation. Feel free to ask questions throughout. We'll also have extra time at the end for additional Q&A. You can ask your questions anytime in the chat window. Feel free to introduce yourself as well and your company so we can start to get to know you. You will be muted the entire time of the call. If you want to jump in, Brian will indicate if you guys can join the call and ask questions in person as well. And again, the session is being recorded, so if you have to jump out early or you know someone that you think would really benefit from this webinar, we will be sharing this on YouTube later today. And just a little bit about LEAP Ventures. So the LEAP Venture Studio and Academy was started with a growth in pet startups in the United States and growing investment in this industry, but we realized there were very few platforms that allowed for companies like yours to scale. And so we are one of the first programs designed to ignite meaningful growth across the pet startup ecosystem. LEAP Ventures is a partnership between Michelson Found Animals and Kinship, which is a division of Mars Pet Care. And the two programs within LEAP are the LEAP Venture Academy, which is hosting the webinar you are on today. This is free programming year-round for any stage pet care startup. In addition to these webinars, we also do office hours. Assad hosted those last week. We also do pitch competitions at major conferences. We have meetups at those conferences so that the founders can get to know each other in person. We hosted our first female boot camp this past fall. We'll be announcing more events shortly, and additionally just access to mentors, advisors, and funding. Our LEAP Venture Studio is our other offering. We have one cohort per year of 6 to 8 startups. The applications for this open in the fall. If you are accepted, there's up to $200,000 in funding, and there are 3 months of programming. 3 of those weeks are in person in LA, and 2 of those weeks are in person in New York City. And we just announced our LEAP Venture Studio companies a few weeks ago, and really excited to have that going right now. And if you have any questions, comments, feedback, definitely email us at leapventurestudio@gmail.com. Also, our Twitter and LinkedIn we post on every week. And if you're not part of our Slack group already, we'll be posting that link in the chat box so that you can join. And with that, I'm going to stop sharing this screen and pass it over to Brian. So I'm going to get his presentation pulled up.
Brian, I love that picture of you.
Thank you.
Okay, so I will.
Yeah, I try to distract from my image by having cute images of puppies or kittens in all photos.
Nice. That's a great strategy.
So this is being shared right
Okay.
now. And there we go. And so you can just switch between the slides.
Okay.
Right there with the mouse.
All right. Hello. My name's Brian Chase, and I'm the general counsel at the Michelson Found Animals Foundation. General counsel means I'm the head of the legal department. Because Michelson Found Animals, even though we're a nonprofit, we're also a scrappy startup. So being the head of the legal department also means I am the entire legal department. I have been here for 7 years and very much love working with found animals because we live at the intersection between entrepreneurial startups and traditional foundation activities. Just as a little background, I went to Wake Forest University as an undergrad. I was a religion major. After exploring all the fantastic career opportunities out there for a religion major, I decided to go to law school. I went to law school at Tulane University in New Orleans, Louisiana. So if anyone has any questions about the law of public vomiting, I am really up to speed on all of that. I practiced at a medium-sized law firm. Well, it's a large law firm by New Orleans standards, medium-sized law firm by national standards, for about 8 years. There I represented a whole bunch of different companies and entities. Mostly I represented shipping companies because that's the big business in New Orleans other than tourism. And I represented a bunch of vessels that for various legal reasons. I'm already getting heckled. So anyway, I represented a bunch of shipping companies, many of which had co-ed crews, which is unusual in the industry. Most vessels are staffed almost entirely by men. But for legal reasons in the United States, a lot of crews have to be co-ed. And when you have a vessel out to sea for 6-7 months and a co-ed crew, you sometimes get some harassment, discrimination issues coming up. And by sometimes, I mean constantly. So when I was in private practice, I defended a whole bunch of employment actions, both wage and hour and discrimination harassment claims. Took a number of them to trial, so I've got a decent amount of experience in that field. After I left the law firm, I went to Dallas to open the first Southern office of Lambda Legal Defense and Education Fund, which is the country's largest anti-discrimination legal group representing the LGBT community and people with HIV and AIDS. I was there for about 6-7 years, both in their Dallas office and in their Los Angeles office. So I got to see the other side of the track and filed multiple claims asserting employment discrimination, public accommodations discrimination, healthcare discrimination on behalf of gay people, lesbians, transgender folks, and people living with HIV. So again, I have quite a bit of background in the employment law field. After that, I was assistant general counsel at AIDS Healthcare Foundation, which is the largest nonprofit provider of AIDS healthcare in the world, with operations in, I don't know how many countries now, but when I was there, it was about 20 countries, running clinics. And so I developed a lot of expertise in dealing with a very large corporate entity because that organization runs at about $1 billion a year. So it's a pretty substantial enterprise. And again, had the same sort of, excuse me, Lord, could you give me a glass of water? Yes. Thanks. The same sort of employment issues that any big employer has. It also gave me a lot of perspective, both on international employment issues and on issues across the United States, because AHF has offices and clinics in 8 or 9 different states in the US. So we had to be cognizant of the employment laws related to all those different jurisdictions. All right, first things first, we're going to be talking about labor and employment law. What the heck does that mean? Oops, already messed it up.
You go back.
There we go. So first, labor law. A lot of non-lawyers kind of conflate these two terms, and that's just fine. But for purpose of this webinar, I want to make it clear that for lawyers, usually labor law refers to laws around labor and union organizing, what employees are allowed to do collectively to try to change working conditions. These laws generally only apply to larger employers. So if you get to a situation where you have employees organizing and trying to form a union or something like that, you know, it generally can be a, thank you, a big legal issue for employers, but in some ways it's a nice problem to have because it's something that happens to employers as they grow. The one thing that smaller employers need to be really aware of when it comes to labor law is that if you've got 2 employees, or if you've got 200 or 20,000, you are barred from discriminating against employees who take collective action to improve or to challenge working conditions. So if your employees form a Facebook group, or whatever the kids are doing these days, if they form a TikTok group where employees are doing interpretive dances to protest unfair labor conditions, you're not supposed to censor those things. If employees get together and 5 employees comes to you and says, we don't think our pay scale is, matching the industry or anything like that, you should consult a lawyer, because even if your employees aren't eligible to form a union, the laws that protect them for collective action to try to improve or change workplace conditions still apply. So if somebody starts a Facebook group saying, we want, more days off, we want to have dogs in the office, in which case you should just say, yes, you can have dogs in the office. But anything like that, you can't start firing people or demoting people or cutting people's pay because they have formed collectively any sort of movement to try to change working conditions.
Brian, can I ask 2 questions on that?
Sure.
One, I imagine that applies to things like Slack groups that's employee managed,
Not
employer managed.
That's super duper complicated.
Oh.
So you should have an employee handbook, and you should have an employee handbook that says, look, we're allowed to monitor and control what goes on in employer-held communications. So let's say you have an internal email server, and employees are emailing each other trying to, say, I hate my boss, I think this guy should get squeezed out. It's much more questionable whether or not that is protected, and it's not a clear issue of law. And I'm using a lot of weasel words here because even though the statute says that you can't take adverse actions against employees for taking collective activity to try to improve workplace conditions, what specifically that means is constantly being interpreted by courts.
Sure.
So the decisions that we have say that when it comes to social media, you're in some pretty rocky territory when it comes to shutting down employee communications, much murkier when it comes to internal communications. Again, I'm not your lawyer, so I can't give super specific advice. And also
That's very helpful.
and the laws change and vary from state to state, and even federally, until the Supreme Court has ruled in. The actual interpretation of federal statutes can vary based on what judicial circuit you're in. So, a federal court in California might rule one way, and in Florida they rule the exact opposite way. And employers in Florida, until the Supreme Court takes it up, are stuck with the Florida interpretation, and employers in California are stuck with the California interpretation. And that's just the way it is.
Totally.
So sorry to be weaselly, but that's about the best answer I can give anyone about that.
That's totally fine. Brian, we do have a question from someone here. Do you want to take it now, or do you want to continue going? How do you want to approach
No, it's fine.
Okay. Shay, do you want to just jump on and ask your question?
Yeah, hey there. Nice to see your face in person. It's Shay
Good.
from Pet Hospice. Hey, you'd mentioned large companies versus small. What defines that? Is there a number, or is there a cutoff? Does it vary?
It varies. It depends on where you are, and I'll talk about that a little bit more. For union organizing, I don't know exactly what the cutoff is, but it's pretty high. Again, it varies from state to state. But realistically, you don't need to worry about it until you're a pretty big employer as far as the labor law side of things go. As far as the employment discrimination side of things goes, which we'll talk about on the next slide, you have to be much more careful regardless of how big you are.
Okay, thanks.
Any other questions on this, or should we move to the next slide?
No, we can move. Thank you.
Okay. Employment law generally refers to how you have to treat your employees. And the big issue here is discrimination and harassment. Originally, the original discrimination laws basically said you can't take an adverse employment action against an employee based on certain protected classes. The traditional ones are race, national origin, sex, and religion. So those are the big ones. And what exactly that means, again, is super fuzzy because it varies based on what state you're in and what federal jurisdiction you're in. But there are a few really bright lines that people need to focus on. Obviously, you cannot say, I'm firing you for being white. I'm sick of white people and we're getting rid of you. That's a classic example of discrimination in the workplace. You have an adverse employment action because the person was terminated, and there is clear evidence that the termination was based on the race of the person who was fired. That never happens, or it happens so rarely as to be vanishingly small. What does happen is that an employer shows a pattern of taking adverse actions against a particular member of minority groups. So let's say you've got a department that is 50% members or 60% members of a protected minority group, and you get rid of the entire department, then you've probably got some splaining to do, and you might be looking at a lawsuit. So regardless of what was going on inside people's hearts and heads when that decision was made, you need to try to look at it from the perspective of, is this going to bring a discrimination claim against us? Now, there are categories of protected classes that have been added by statute in various states. So federally, it's perfectly legal to take adverse actions against somebody for being gay or lesbian. There are currently some issues, currently some cases in the federal courts that argue that the current laws against discrimination on the basis of sex also includes discrimination on the basis of sexual orientation. Those have hit different decisions in the U.S. Courts of Appeal. There are currently a couple of cases that are before the U.S. Supreme Court. The Supreme Court has not accepted review of any of those cases yet. So, stay tuned. Judging based on the current composition of the court, it's probably either not going to get resolved or not going to get resolved in favor of employees in the near future, but who can say? But lots of states, especially coastal states, have statutes that say you can't take an adverse employment action against somebody based on their gender identity, based on their sexual orientation. So it's important to know the laws where you are. As a general rule, you can assume that if you're in Texas or Florida, the employment laws are going to be a whole lot less strict than they are in a state like California, where they are King Kong mega strict. And we'll get into a little bit more detail about that later. But especially if you're in California, before you fire someone or before you demote somebody or cut their pay, you probably want to have a chat with somebody who's familiar with these laws, whether it's an HR professional or preferably a lawyer, just to make sure that you are protecting yourself as best you can. I say preferably a lawyer, not because HR professionals don't know this stuff, they generally do, but HR professionals are legally barred from giving concrete legal advice because that would be practicing law without a license. So you're usually going to get somewhat more candid feedback from a lawyer. Also, communications between a lawyer and a client are generally protected and can't be introduced in court. Whereas an HR professional, if it's just a manager and an HR professional chatting, both of them can be sat down for a deposition. Whereas if it's an HR professional and a manager and a lawyer talking, then arguably that whole conversation is privileged and you can't be asked about it in court. And that can become very important later.
Brian,
I'll talk briefly about the difference between harassment and discrimination. Under federal law, there's no statute that says you can't harass female employees. You can't harass African-American employees. However, the courts have interpreted the law to state that harassment is a form of discrimination. So even though the statute doesn't expressly say it, you can still get sued for being mean to somebody if that person can prove that the reason you're being mean to them is their race or their religion. Another thing that people should be aware of is what's called the Price Waterhouse decision. So that says that sexual discrimination includes discrimination based on sex stereotypes. So in that case, a partner at PricewaterhouseCoopers, the big firm, was a woman who had a very masculine physical appearance. She didn't wear makeup. She wore perfectly appropriate business attire, but she wore suits without a skirt. She wore pantsuits. She presented in a way that her superiors thought was very masculine. She was, God forbid, aggressive. And, you know, she went to court and the Supreme Court said, look, you would never discipline a man for wearing a suit, for being aggressive in meetings, for not wearing makeup. So the court said, this is clearly sex discrimination, even though you didn't come out and say that the problem was she's a woman. You did come out and say the problem is she's a woman who doesn't act the way that you think a woman should act. That's discrimination. So be super careful on that end of things. I've had a number of clients who think they can weasel their way out of discrimination cases by, you know, throwing up a bunch of pretextual reasons why they took an employment action against somebody. That rarely works. And it's a really, really, really good way to crank off a jury. Remember that if an employment discrimination case goes to a jury, and it's really hard to get these cases thrown out before they get to a jury, if it goes to a jury, you're not going to be in front of a jury of bosses. You're almost certainly going to be in front of a jury full of employees who may or may not like their boss. So even if you think you did everything right, it's very important to be cautious on these issues because you're most probably going to have your fate decided by a bunch of people who are sitting in a jury box and work 9 to 5 and see things happening in their workplace that they might not think are fair, and they might be more than happy to take it out on you. So this is one of those areas of the law where you really have to be super cautious. And I'll talk a little bit more about that later. Oh, questions?
Sorry, yeah, 2 questions from Dan. One is, what if you are a U.S. entity but have people locally and overseas? Does it apply to the U.S. employed folks only?
Probably. Okay. It really, and again, I have to weasel a little bit on that because it's going to be a fact determined. It's going to be a very fact-specific situation. If the person doesn't take any face time in the U.S., if the person, let's say they're a coder who does all their work overseas, all their work is via teleconference and on the computer, then it's likely that the law is not going to apply to them. Whereas if you have somebody who's a global sales rep who happens to be based in Amsterdam, but they're bouncing back and forth to the US and you're there and the other, then it's more likely that the court's going to find that US laws have some jurisdiction. It's not an issue that comes up very much, so there isn't a lot of clarity around it. So be careful, but you also have to be cognizant of the fact that a lot of countries have much stricter employment laws than the United States does. The US is actually kind of behind the curve when it comes to developed nations or economically advanced nations on this. So, you know, if you've got an employee in Amsterdam, again, you want to be super duper cautious because Dutch laws, especially around labor organizing or English laws or German laws or French laws, are going to be a whole bunch more strict than the US. So again, I can't give you a super specific answer, but that's what I can kind of tell you at the 10,000 foot level.
And one other question is, what if I'm a boss and I don't like someone on a personal level, like hate being around them or feel very uncomfortable? Is that a valid excuse, I'm guessing, for firing that person?
Yes, comma, but. you have to remember that a jury can't read your mind and a judge can't read your mind. So if somebody is a member of a protected class and you just think they're a jerk, or you think they're too quiet, or you have some other fairly subjective reason for wanting to let them go, you probably want to think long and hard about it. And again, I'm going to talk to you later about why it's so important to think long and hard about it. The short answer is it can cost you a lot of money if you don't. So yes, legally, I don't like you is a perfectly valid reason to let somebody go. Will that necessarily prevail in court, even if it's the truth? And not so much. So we'll talk about that a little later. So the answer to your question is, yes, it is, but be careful. So I'm gonna talk, and are there any other questions on that?
Nope, that was it.
Okay, cool. I'm gonna talk about laws protecting disabled people. Both federal and state laws require employees to provide what is called reasonable accommodation for disabled people. And the definitions of those terms are kind of fuzzy. So that's why it's really important to, again, consult with a lawyer and know what the issue is. Because, I used to be a civil rights lawyer. I am very sympathetic to folks who have actually suffered from employment discrimination, real employment discrimination. But I've also been in-house counsel for a long time, and I've seen lots and lots of cases of somebody who's doing a bad job at work, runs out to the doctor, gets a note saying, they got to be out for a month, and then gets another note from the doctor saying, we need some ridiculous accommodations at work. And they are clearly and obviously and 110% doing it just to make it tough, because they saw that they were going to get fired and they want to keep getting that paycheck for as long as possible. It happens. I mean, I have represented, I represented in a public accommodations case, a guy whose mom brought the suit because he was at a nursing facility at the time. But the nursing facility he was rejected from 6 nursing facilities that flat out said that they wouldn't let him in because he had HIV. Even though they were perfectly capable of taking care of him, and he wasn't actually sick due to HIV or AIDS. He had been in a car crash. He had absolutely no AIDS-related illness. There was nothing that they couldn't take care of, but they flat out said, we don't want to deal with somebody who has HIV. Shockingly, I won that case because that's a real easy case to win. That's not how things usually shake out. Usually, things shake out on what the definition of disability is and what the definition of a reasonable accommodation is. So first, we'll talk about what is a disability. Under most state laws and under federal law, a disability means something that interferes with a regular activity of a person on a permanent basis. The obvious example is blindness. The need to use a wheelchair, an injury that prevents you from lifting a certain amount of weight. Those are obvious disabilities. Things like emotional problems become much more fuzzy. Certainly somebody who has chronic depression that is well documented might be considered disabled because they've got a chronic condition that is not amenable to a treatment fix, at least not in the short term, and it regularly interferes with big activities of life, like interacting with other people. Or chronic anxiety. This is one that lots of employees assert as a disability that requires lots of accommodations on the part of their employer. That gets pretty fuzzy because a lot of time these folks, they haven't tried to take any medication that might alleviate that anxiety. Obviously, if they're too stressed out to come to work, then that's not something that can be accommodated reasonably by their employer because they just can't do the job. So again, there's a spectrum of some stuff that is clearly a disability, some stuff that might be a disability, and some stuff that clearly ain't a disability. So let's say you've got, mono. That's not a disability because it's a disease that clears up after a while. And federal and generally state law, even though there are some state laws that do protect people who have a short-term illness. But for the most part, if somebody's just sick, but that means that they can't come to work for, I don't know, 2 months, they might be able to take medical leave or something like that, which would be protected, but they wouldn't fall under the disability discrimination laws, because anything that's going to clear up on its own or with treatment is not a disability. I'm also going to talk a little bit about folks that want to bring pets to work as service dogs or support animals, because that's an issue that comes up quite a bit. Here at our office, we have a pet-friendly policy, so we couldn't care less if somebody has a service dog or emotional support animal, because everybody gets to bring their pet to work, to be honest, unless that pet is misbehaving, or the pet is making, a ton of noise, or the pet is an emotional support hippopotamus, which we're just not going to let in the office. But here's where people get real confused on this. A service animal is an animal that is allowed in a workplace or any other public place, so long as allowing them would be reasonable, under the Americans with Disabilities Act. So if you have an actual service dog, you can bring them to work any place in the US unless you can show that allowing that would be completely unreasonable. So let's say you're a surgeon. No. A surgeon cannot bring their service animal into the operating room for obvious health-related reasons. That would not be reasonable. But if you got an office job, you can bring your service dog. But service animals are very narrowly defined. And a lot of people think that they can just go out and get a note from their doctor that says, I need to have my dog with me, and they can't be fired or disciplined for that, or the employer can't say no under the Americans with Disabilities Act. That's baloney. A service dog or a service pony or a service horse, which are the only animals that can actually be service dogs under the law, are specially trained animals that are there to do something very specific for their owner. A seeing eye dog is the classic example. They go through months of training to assist visually impaired people. That's a service dog. A dog that is trained to help somebody with PTSD is a service dog. So if you're a returning veteran and you go to get a service dog that has been specifically trained to react to you when you are exhibiting symptoms of PTSD, that's a service dog. If your doctor says you need to have your lap dog with you all the time because you're depressed and having the lap dog with you makes you happy, then that's a support animal. And support animals are generally not required to be allowed in a workplace under the Americans with Disabilities Act, because they haven't been trained to do anything. They're just there to make you feel better, which is awesome, and I love support animals, and some people really need support animals. But there is a really stark legal difference between the two, and a lot of employees try to take advantage of that fact by coming in to work with a note that says, I've got to have my kitten with me all the time, which they might really need, but that animal is not a service animal. And it's important to remember and know the distinction between them two, because this has been an issue that has been abused a lot by folks. People who actually have service animals are now getting very cranky about fake support animals that are certified. There are literally online services right now that will certify your animal as a support animal without ever seeing you, without ever seeing the animal. And people who need to have their actually trained service animals at work are pushing a movement right now to have that kind of thing banned, because a lot of places are saying we're not letting any animals in response to a lot of fraud on the subject. So anyway, that's kind of the long and short on service animals. As far as disability goes, what you don't want to ever do is ask a person what their disability is. So if they come to you with a note from their doctor saying, I need to work remotely 2 days a week, that may or may not be reasonable depending on what their job is. Obviously, if they have a job that can't be done remotely, then it's a lot more unreasonable to say that than if it's a job that can easily be done remotely. But what you need to be aware of is you can't say, well, what the heck's wrong with you? You can't ask specifically, what's your problem? What you can do is ask for a doctor's note that doesn't just say, this person can do whatever they want and doesn't have to go to work whenever they want. You can ask for specifics. You can say, what specific accommodations does this person require in order to still work with their disability? You can also ask for an independent medical evaluation. You can ask for a third-party evaluation from a doctor that says that, this person actually, has these limitations, or this person doesn't have these limitations. Neither one of these is going to be absolute proof if you end up getting sued, but it's going to help a lot if you sent the person to a doctor and that doctor says, nah, this person actually can come to work every day, they just can't lift more than 25 pounds. Another thing to be aware of is if you get a doctor's note from a doctor who clearly should not be making this sort of medical evaluation. If somebody comes in and says they've got chronic depression and they need to stay at home 2 days a week and it's from their chiropractor, no, flat no. You can say, please go to a mental health professional and we will consider your request for accommodations. And you should probably say that in writing, and you should probably say that with the help of an HR professional or an attorney or somebody who knows how to phrase this in a super innocuous way. But that's a big red flag if an employee comes to you with a note from a doctor who is clearly operating outside of their lane.
Right.
So that's just one more thing that you should look at. Let me look at my notes.
Can I ask a question on that?
Yep.
And Jessica has a pretty specific question that she wants to ask, but my guess is that you can't provide specific responses.
Yes.
But just building on what you said, if you find out that someone's trying to scam you, is that grounds for firing them?
Yes, it is. That's a really good question, but you better have some really, really good documentation of the scam. But that is totally grounds for dismissal. And as a matter of fact, the courts have held that even if you find out after the fact that they were terminated, that they were scamming you or they were doing something illegal, then the termination can be retroactively validated. So let's say you terminate somebody for perfectly legit reasons, and then over the course of discovery in a lawsuit, you also found out that this person has been Xeroxing a bunch, or I just said Xeroxing, I'm so old. Scanning and PDFing a bunch of documents that they have no business scanning and PDFing and sending to their personal Gmail account. But they were obviously doing it in anticipation of a lawsuit or as a means to try to embarrass their employer later. That's grounds for dismissal. And if you find that out during the course of discovery in a lawsuit, you can bring that up and you can say, look, this person was doing all sorts of skeevy things that we didn't even know about. Don't rely on that because chances are you're not going to come up with great evidence like that. And if you do come up with great evidence like that, it's probably after you've spent $100K on dealing with a lawsuit that you'd rather not be dealing with. So the answer is, again, a resounding yes, but. Any other questions?
No, Jessica, let me know if that didn't answer your question, but I think that I got to the gist of it.
Okay, I got to hurry this up along. I wasn't expecting to talk so much. Family and medical leave. Okay, some states require you to give employees, even part-time employees, paid sick leave. Some states don't. All U.S. employers are required to give unpaid time off under the Family Medical Leave Act. So again, you got to be careful if somebody's taking sick time to not ask exactly what the condition is, but to get doctor's notes as necessary from appropriate providers. Also, it's important to make sure that you're doing the karmically correct thing here. Even if they are too new an employee to qualify for family medical leave and they have to go out for cancer surgery, you might be able to get away with it legally, but it's really not a good thing to do if you can give the person some time off. It doesn't look good. It looks bad to any prospective employees that ever hear about it. So you don't necessarily always want to just be thinking about being sued. You also want to think about how this is going to look when somebody posts on Glassdoors. So that's all I've got for that. Next one's a big issue that I'll try to go over quickly because I talk too much. And if people can stay on, I can stay on as well to entertain more questions. The 1 hour is not a lot. Do I really have to pay these people? This is an issue that comes up constantly. It is a complete landmine for employers. Wage and hour laws can make your life completely miserable, especially in California, where you have to pay super strict attention to them. And you can get into lots of trouble for underpaying people for just a little bit. So you really want to be careful on those. You want to be careful on final paycheck laws. In a lot of states, you have to cut a terminated employee's paycheck on their last day. You can't wait till the next pay cycle. You need to have a very good system in place to track hours. You need to make sure that employees are recording their time and they're getting paid for every minute that they are recorded. That is the employer's burden. If an employee just does a bad job of recording their hours and you end up paying them just for the hours that they badly recorded and you don't pay them for the time they're working off the clock, you're still on the hook. And you can get sued, and that lawsuit, even if it's over a relatively small amount of unpaid wages, can result in a whole bunch of awful, terrible, and horribly expensive things for you. So you've got to make sure that people are reporting their hours. If an employee is deliberately working off the clock, that's not a defense. So if an employee just decides to work off the clock, you can discipline them, you can write them up, and I strongly suggest you do. You can even fire them for it. What you can't do is not pay them for it. And I've had this issue come up, and what you have to do, if you find out people are working off the clock because you're a startup and people are scrappy and they understand you don't have a lot of capital, tough. If you find out somebody's working off the clock, write them up for it and pay them for all the time that they worked off the clock and get them to sign something saying, these are the hours I worked off the clock. Doesn't necessarily protect you from a lawsuit, but it is something really good to show the jury. It's like, look, I found out they were getting underpaid. I asked them again and wrote them up and said, give me all the hours that you didn't pay. Then I tried to pay them. And that's the best protection you can have. But really, this is a very employee-friendly area of law. And one thing that you need to know, especially as you grow, is that in a wage and hour claim, usually an employee can roll together other employees into a cause of action against you. So especially in California, let's say you have one employee who hates your guts and 100 employees who love you. That one employee who hates your guts, if they've got a halfway decent argument that some people are being underpaid, they can file a claim against you and name all the other employees who have been underpaid. So what started with one cranky employee who's probably a jerk turns into a major legal issue related to a bunch of employees that didn't want to be involved in the first place. So this is one area where you really can get in trouble. One area where you can get into trouble where you don't even realize you're doing it is in classifying some employees as exempt and some employees as hourly. An exempt employee is an employee like me. I'm a lawyer, I'm a licensed professional, therefore I get paid a salary. If I work 15 hours a week, if I work 150 hours in a week, don't matter. I get paid exactly the same amount. And that's perfectly legal when it comes to me. Because in every state, a lawyer is a licensed professional who can be classified as exempt. These laws vary from state by state. So federally, if you're an accountant, you can usually classified as exempt and you can be paid a salary. In California, only a CPA can be classified as exempt. So if you have somebody who's an accountant, no matter how talented they are, who is doing the same work as a CPA, you can classify the CPA as exempt and just pay them the same amount every week, no matter how many hours they work. You cannot classify that accountant the same way, even if they're doing the same work. One place where other folks really mess this up is they classify administrative personnel as exempt and pay them a fixed salary rather than paying them by the hour. A lot of employers love doing this because it gets them out of paying overtime. It's also totally illegal and can get you sued. Um, there is something called the administrative employee exception to the wage and hour rules, and I've had many arguments with clients who want to classify everybody as an administrative employee because they sit at a desk all day. That's not what it means. Administrative employee means somebody's a boss. So basically, unless they're a licensed professional or they have a whole bunch of people answering to them, if they have a bunch of direct reports, then they're probably, it possibly can be classified as exempt. But most people who work in an office, even if they have a few people reporting to them and they're responsible for a budget or this, that, and the other, and they have some independent authority, usually you still need to pay them by the hour. If you have a choice in the matter, always err on the side of paying people by the hour. This can be an issue for HR sometimes because some people get really offended when you want to pay them by the hour because, you know, I went to a fancy college and I'm smart and I want to be an exempt employee like all the big bosses are because, you know, they want to work real hard and they don't want to have to deal with recording their hours, and they don't necessarily want to get paid overtime because they want to impress the boss by the number of hours they're working and they don't want to get their overtime approved. I get it. It's a pain. But if you ever have to fire one of these go-getters who has been misclassified as exempt, they might turn around and file a lawsuit for all of those unpaid hours and all that unpaid overtime, and that can get real expensive for you real fast. So again, I could do an entire presentation on who's exempt and who isn't, but this is an issue where you really, really got to be super careful because it gets employers in trouble all the time. The last thing I'm going to talk about is one thing that came up in the questions from our survey. Who is and who isn't an unpaid intern? Quick answer: nobody is an unpaid intern. That's something of an exaggeration, but not much. Decades ago, lots of very high prestige employers like publishing, like filmmaking, like, I don't know, what else is fancy? Accounting. A lot of these professions had a bunch of unpaid interns around because, especially like fund management. Because a lot of folks with a freshly minted BA from Wharton or who had a freshly minted film degree from NYU wanted to get their foot in the door. And a lot of them have rich parents, and they were more than willing to work for free in order to show what they could do and hopefully get a job later on. And this was the common practice in these prestige industries for a long time until, you know, some of these folks realized that they were getting used for free work. And some class action lawyers realized, hey, I can sue Paramount for $1 million bajillion. So that whole thing has gotten shut down hard. If you've got somebody working for you for free because they're an intern and they want experience, forget about it. Put them on payroll or tell them we appreciate it and get out. Or if you really want to be careful, retroactively pay them for all the time they worked. But there is really no such thing as an unpaid intern, with the one exception. If that person is actually getting university or college credit for doing the work, they might be possibly an unpaid intern, maybe kinda. But you have to make sure that the university's cool with it, the university is keeping track of their hours, that they're actually getting some sort of educational experience. If the primary reason that they're there is to network and meet people, that's not enough. So if you've got an unpaid intern who really wants to be an unpaid intern and their university says, sure, we're going to give them university credit for this internship, but you stick them in the mailroom and they're sorting mail all day, tough. And it's not the university who's going to get sued for that. It's the employer who's going to get sued for it, even if the university signs off on it. So with unpaid interns, be super duper careful. The only real exception to this is if you're a nonprofit. Nonprofits can have employees and not pay, volunteers and not pay them. You can call them interns, you can call them whatever you want, but that doesn't apply to any of you because you're all plucky startups that are going to make bazillions and billions of dollars in profits. But if you have a nonprofit arm or something like that, then yes, you can use volunteers as long as they're not doing exactly the same work as paid employees. But that's, again, a place where a lot of startups get into trouble. I've got friends who are, YouTube celebrities, and they all have an unpaid assistant. And I keep on telling them, don't do that, because, the bigger you get, the more likely you're going to get into trouble for it. I think that's all for that one. Yeah, but the same thing is if you have an employee who is claiming back and forth that they are volunteering to do extra time, no, that's not okay. It's not cool. Even if everybody consents to it, can't do it legally. And it's one of those things that can get you in a lot of trouble. All right. This is the important part about employee law. Most of the time, I don't know if most of you have experience dealing with law firm lawyers. Most of the time when you go to a law firm lawyer, they are going to give you the most cautious answer to any question you ask them. Because if they tell you to be super cautious and you lose a deal because of it, not the lawyer's fault. If they tell you to be super cautious and a deal moves more slowly and you end up losing a bunch of money that you could have made had the deal closed earlier, usually not the lawyer's problem. So, but if a lawyer tells you, hey, there's no risk here, and you end up getting sued and it bankrupts you, then the lawyer can get into a lot of trouble, either representationally or possibly in malpractice. So lawyers and law firms have very strong incentives to give you cautious advice. And I'm telling you this because as an in-house lawyer, my general perspective is to say, hey, this is what the law says, and this is what the potential downside consequences are for you. So I can look at a contract and tell my boss, look, I see this legal issue, this legal issue, this legal issue. Are you going to get sued over it? Almost certainly not. Are you going to get in trouble with the IRS if you're not like 110% accurate on this particular filing? Probably not. Even though I wouldn't ever suggest anybody, mess around with their IRS filings, you're probably not going to get audited. And you can talk about if you have to. I've seen issues where a technical, very strict reading of IRS regs would require thousands of pages of disclosures. And I can look at the cases and say that literally the IRS has never prosecuted anyone for not doing that, and it would be incredibly expensive to do it. So I can say, you're probably not going to get in any trouble, even though a strict reading of the law says you might. This is not the case in employment law, because in most employment cases, the employee, if they prevail, can get attorney's fees. So if they sue you for $500 in unpaid wages and they win, and their attorney reasonably racked up $100,000 in time to win that case, then guess what? You're on the hook for $100,500. And believe me, that can rack up real fast. A competent employment lawyer can usually get a judge to agree that their time is worth $400 to $600 an hour, especially if you're in a big city like New York or LA, where fancy law firm lawyers go for $1,000 and up. So it can really be the tail that wags the dog in these employment cases. Also, if you do something super egregious, they can get what's called punitive damages, which means we hate you and we want to punish you damages. So even beyond the actual loss of wages, if you do something super nasty, and that happens in a lot of harassment cases, especially with lawyers, because lawyers in big firms seem to think they can get away with whatever they want. So there are a lot of, one classic case is a lawyer at a very, very large California firm with a huge international presence thought it was totally cool to drop M&Ms down female employees' blouses. Shockingly, the court held that that is not okay. And the firm not only got whacked with, lost wages and stuff like that, they got whacked with punitive damages to the tune of millions of dollars. Because everybody knew this partner was doing it, and nobody wanted to do anything about it because he brought in a lot of business and he was making a lot of money for the firm. So, that's why I have this graphic up here, because a lot of big shots in a lot of big industries think that boys will be boys is a defense. Is not a defense. And when it comes to employment law, you need to be super paranoid about it. And I'll tell you, in most fields of law, what you're dealing with is one business person, another business person who want to get a deal done, and they don't have any incentive to sue each other. and they want to do business in the future, so there probably isn't going to be a conflict, even if every single element of a contract is not perfect. When you're dealing with employment law, there is no such incentive, especially if you fire somebody, especially if you demote somebody, even if you just write somebody up. A lot of people will get their fees hurt and will run to a lawyer, even if you haven't done anything wrong. And in employment law, unlike in regular lawsuits, the employee can run to a federal or state agency before they even file a lawsuit. So that is so the cost of filing fees and all that stuff isn't even an issue. In California, if you've underpaid an employee, they can go to the Department of Industrial Relations, file an unpaid wage claim. They don't have to file any filing fees with the court, which can be thousands of dollars. So there are lots and lots of attorneys who are willing to take these cases. And I shouldn't use the term bottom feeder to decry any members of my noble profession. But the fact of the matter is there's a lot of lawyers out there who can't get jobs. And if you can settle, the cost of actually taking an employment case to trial, even if it's a garbage case, is going to be hundreds of thousands of dollars. So settling these cases, even garbage cases, usually goes for $70,000, $80,000 because they know you're going to spend more than that to defend the case. So again, this is an area of law where you really want to be super cautious, because if I'm a lawyer who got really bad grades at a really bad law school, but somehow manages to pass the bar, and I can get 10 or 11 garbage cases a year and settle them all for $50,000, and I get 30% of that, that's a halfway decent living. So you're making a healthy six-figure income off of what can charitably be described as a shakedown. It's not pretty, it doesn't comment well on my profession, and unfortunately it hurts people who have really legitimate claims of discrimination, but that's just the way it is. So again, most areas of the law, you can be a good business person and assess the risks, and just go forward. In employment law, be paranoid. What's up?
Sorry, we have 1 minute left before the scheduled for this, and so I just want to, if people need to bounce, we totally get it. I think Brian said that he could stay and answer a couple questions. Do you want to get to some questions? Do you have some final thoughts that you want to share?
Yep, I'll show my last slide and then we'll go to questions. Last slide, can I make everybody independent contractor or make this go away? No, you can't. If you're hiring, and entrepreneurs love doing this. Like, everybody agrees, we've got a contract that says you're an independent contractor. Nope. The test for an independent contractor is if they're doing the work all by themselves and they're in control of the work. And in California, this test is even more strict. If it's your plumber who owns a plumbing company, if it's your law firm, if it's an ad agency, if it's an outside company that has its own employees, you're fine using them as an independent contractor. If it's a solo consultant or whatever, you're probably not allowed to make them an independent contractor. Be super duper careful with this. Again, if anybody has questions, I'm happy to answer it. But this is another big landmine. Avoid it. And now I'll shut up. All right. Any more questions?
Yeah. Nora had a question, and I think it was about that contract. What's the difference between an employee and hourly contract and non-employee when it comes to these cases?
Independent contractors cannot sue you for discrimination usually. Independent contractors, you don't have to deduct Social Security and other payroll taxes from their pay. You just write them a check. Independent contractors are not eligible for overtime. Independent contractors get a lot of tax breaks sometimes, depending on their profession. So a lot of people want to be classified as an independent contractor. And it's the burden on the person hiring that independent contractor to make absolutely sure they are an independent contractor. I'm not aware of the laws in every state, but in California, if you misclassify someone as an independent contractor when they should have been an employee, not only are you on the hook for their payroll taxes or any unpaid overtime, you can also get fined. And the fines are big, like $5,000 for the first violation, and they can roll together a bunch of different people you've classified as contractors and give you one big fine. And as glacially as some government agencies can move, when you put a big chunk of change on the table that the agency actually can collect, you'd be amazed how industrious they suddenly become. So again, the The big distinction is if you are hiring an outside IT company that has employees, you're safe. If you're hiring an outside construction company that has its own employees, you're safe. If you're hiring somebody who used to be at, people do this all the time, somebody who used to be at McKinsey or Bain or one of the big consulting companies, you hire them as an independent consultant, but they're working full-time for you, and you're basically telling them what you want to do. They're not a consultant, even though their job title and their contract and everything else says they're consultant. Any more questions?
Yeah, just like
Did I even answer that question? I'm not sure.
yeah, no, I think my question, and we have two other questions that come up, but a lot of startups when they first start out will hire independent contractors on like 6-month agreements or 6-month contracts,
Right.
and determine if they want to go full time. Are you saying that they essentially are a part-time or full-time employee for those 6 months? Is that what I'm
Absolutely. And it's perfectly fine to give somebody an employment agreement that just clarifies the fact that they're a part-time, that they're a temporary employee. And that's what I advise people to do all the time. Just put them on payroll and tell them you're gone in 6 months. And if you keep them longer than that, fine. But as long as you set the expectation at the beginning of their employment term, you're probably going to be very safe. But when in doubt, put them on payroll.
Okay.
And I know that tech companies especially do this all the time. But especially under recent California Supreme Court law and recent California statutory changes. In California, it's a horrible, absolutely terrible, rotten idea. In the rest of the country, it's just a terrible idea.
Great. Dan had a couple questions. Dan, are you still on? Do you want to pick one of them and ask? Dan, are you there?
I didn't like Dan anyway.
Oh, okay. So Dan, one question he had was, can you explore a bit on the balance between 1, cost of engaging in a legal battle, 2, paying the trouble person a compensation so he or she leaves, 3, keeping that person for some sort of other option? And he asks, what's the budget range we were talking about?
It depends on the jurisdiction, on my weasel, and it depends on the employee and how big a pain the employee is. I usually recommend if you think somebody's going to need to leave, to give them at least 2 weeks severance per year of service, possibly more. And it very much depends on the situation. If you've got a employment practice where everybody's basically the same color, everybody's straight, everybody's basically the same religion, nobody's been discussing any sensitive issues at work, then you can probably err on the side of giving them less severance, a smaller severance package, because you are just realistically looking at less exposure. If you've got, an employee who's the only racial minority in your entire workforce, and that's the person who you decide to get rid of, for good or for ill, whether your heart is pure and you want to do it just because this person is the dumbest person you have ever met, or this person is irritating you, whatever, you have a lot more exposure, and there's a much higher probability that this person is going to walk into a law firm that specializes in this stuff, say, I belong to such and such minority, I was the only person in this minority in my workplace, and I got canned. They're going to take that case. And I'll tell you why they're going to take this case. In employment actions, there's something called burden shifting. So let's say that you're a member of a protected group. Let's say you're a member of a very small religious group, and you have a layoff at work. And coincidentally, out of your 50 employees, the only 2 people that got terminated are the 2 people who are members of this small religious group. They don't have to prove their case anymore, because at that point, when you have taken an employment action against members of a protected class, and you haven't taken similar action against similarly situated employees who are not in that protected class, the burden shifts to you to prove that your motives were pure. So that employee no longer has to prove anything in court. It's up to you to prove that you fired them for legal reasons. So that's the reason that you might want to think about giving them more severance if you're going to take that action than you would normally, because they've got a lot more leverage over you. So my general rule is try to get somebody to take severance. It can be galling. I have had to really, really have hard conversations with my bosses at various times about why you should pay this no good, lazy, rotten employee severance, even though they don't deserve it. They were let go for clear cause. And and it just feels awful because it feels like you're rewarding somebody for being a rotten employee when all your great employees are not getting 6 weeks pay for doing absolutely nothing. But as a general rule, if you have to hire a lawyer, and one thing that's important to know is corporations can't represent themselves in court. So if somebody walks into a lawyer and they get a legal representation who takes their employment claim, unless you've got insurance that's going to pay for your lawyer, which most EPL, employment and professional liability policies, will pay for your lawyer, you can't just march into court and defend yourself. And a lot of times, even if you have an in-house lawyer, the in-house lawyer can't always represent you at some stages of a proceeding because in-house lawyers are considered management. So I can represent my employer up to a point. But at some point, even though I'm pretty well versed in this law, I'm going to have to run out and hire somebody. And that's going to cost me $600 an hour of their time. And if there's a lot of paperwork to review, and believe me, law firm lawyers love to review paperwork. They will have some associate who's billing you at $400 an hour go through a tremendous amount of papers, all this person's payroll records, everything. So you're looking at 10 hours right there, $500 an hour. You're talking $5,000 before you've even got out of the gate. I have had cases where I was not thrilled with my outside counsel's representation, but where they charged me $40,000 to $50,000 without creating any briefs, any memoranda, any actual written work product more complicated than an email. But just going through all the employment records and everything the other side filed and getting ready for mediation, which requires going through all those documents again, is very costly, even in a specious claim. So this is a thumbnail. If you can get a severance agreement, and you need to have a lawyer make sure that your severance your agreement is ironclad, but most good and honest employment lawyers can do that for you for under $1,000, because it's basically reviewing a form and making sure the form works for whatever state you're in. So if you've got a lawyer who's charging you $10,000 to do a severance, get another lawyer, because severance agreements should be super easy and quick. But if you can get a good tight severance agreement from an employee who you have let go for under $5,000, unless that employee is not a member of any protected class and has no sort of wage claim or anything that you can imagine, I'd say take it. If an action gets filed, whether it's an administrative action and you can get out from under it for about 30, as horrible and painful as that is, generally I'd say take it. Again, depends on the circumstances. And I know it has a lot of zeros to it. But these plaintiffs' lawyers, again, because they get attorney's fees, they don't mind racking up the hours, because as long as they're on the clock, then your potential exposure gets to be more and more and more and more, and there gets to be a point where they're not going to settle for less than 6 figures, even if they have a garbage claim, because they know that you're going to spend more than that going to trial. Trials are crazy expensive. So again, long answer with not a whole ton of specifics, but generally, if you know you've got a disgruntled employee, and you can get out from under it for $5,000 with a super solid severance agreement, do it. Obviously, it varies. If you've got a $200,000 employee, your exposure is a lot higher than if you've got somebody making 20 bucks an hour. So you've got to evaluate it on a case-by-case basis. But if a few grand will make them be quiet and go away, then you're probably much better off having them be quiet and go away, even if it's really galling to write a check to somebody who you know doesn't deserve it.
Brian, I'm going to do one more question, and I think I'll end it here. Liza just wanted to know, what if someone gets a salary like an engineer or sales reps? Does the employer still need to track the hours?
Your sales reps probably should not be getting a salary unless they're managing other people. The answer is if somebody is properly classified as an exempt employee, then you totally don't need to have them track the hours. So if somebody is an MD, if somebody is a licensed attorney, if somebody's a CPA, you can track their hours if you want to, but legally there's no reason you have to. If you've got somebody who is questionable whether they should or should not be classified as exempt, and as a business decision, you decide to pay them on a salary, which is risky, you should probably be tracking their hours just so if they come back and say, you fire them, they come back and say, you were paying me for 40 hours a week, I was misclassified, I should have been hourly all the time, and by the way, I was working 70-hour weeks and I never stopped working, then at least you've got evidence that says, no, you were working 35 hours a week, we've got your time records. So that's the best answer I can give you on that. Unless you're really, really certain, if somebody's the CEO, if somebody's the lawyer, then you can totally classify them as exempt and pay them a salary. If somebody's more questionable, then you would best track their hours.
Brian, thank you so much. Really appreciate this, and thanks people for staying a little bit longer. Isabel and I are very grateful. This could go on for like another day and a half if we wanted it to, and luckily Brian is hosting another webinar next week, so hopefully we'll see some of you guys next week. Is it next week, Isabel? Remind me.
Next Wednesday.
Next Wednesday.
Thanks for coming, everybody, and if there's any interest in a follow-up on anything more specific, we can obviously try to schedule that, so feel free to contact Isabel and let her know. If there's a ton of extra questions, we can set up another hour, or we can try to.
Yeah, that's great. So people, Dan, I know had a couple questions. We'll collect them and then we'll get back to you. But thank you all for joining, and we'll talk to you all soon.
Thank you.
Thank you very much. Bye-bye.